All righty, still with us is NEAMA RAHMANI, who's a former federal prosecutor and wrote the book, Harvard to Hashtag. I love that name, can't say that enough. And DINA Dahl is with us. Haven't seen DINA in a while, but great to have her on the show. She's got it all. She's an attorney, she's a mediator, and she is a trial consultant. She's three things wrapped into one. DINA, let me go to you first. Interesting, the defense attorney, I thought, did an effective job. He went and talked about all the things that they didn't see, which down the road he's going to say is something you would expect that you would see. So what was the value of this witness to the government, and did the defense do a good job in your mind neutralizing the witness?
You know, I think we've seen a lot of these types of witnesses in the last few days, which is setting the foundation. They're trying to show that the evidence was collected properly, that it was kept securely. That way it can be actually admitted later. The analysis of what they found, we are most likely going to hear from another witness, which will make this more revealing. But I think that the defense has done a good job, not only with this witness, but all the foundational witnesses, with raising doubt in their questions, as you said, kind of showing what they wouldn't, what they didn't find. And I think that every time they do that, even if they maybe aren't like slam dunk revealing answers, I do think it's effective in what they ultimately, are trying to show, that the prosecution hasn't overcome this reasonable doubt, and every little bit of doubt that they reveal is helpful.
All right, DINA, I want to ask you a follow-up question, because we already gave NEAMA and our previous guest Matt an opportunity to answer this. I'm questioning, as a former homicide prosecutor, the government's extraordinary attempts to get in this 404 other act evidence. That is the financial issues, the financial crimes, and the connective tissue they're trying to say to the jury that is established by clear and convincing evidence, which is a firm belief, is the fact that these are the things that would have caused him to murder his wife and his son Paul in order to deflect responsibility. Now, this is a lawyer. I'm wondering whether or not, in summation, the defense is going to say this is an attorney. He knew the gig was up. He knew they were on to him. And moreover, the state's own witness that they called, again, a self-inflicted wound, said that Paul was the apple of the defendant's eye, that he had a great relationship with his wife. And I assume the defense is going to also introduce, perhaps down the road, all this testimony to say this is not a raving lunatic. This is not the kind of guy that goes out and just kills somebody because he wants to distract attention of people he loves. Could this come back if they introduce this evidence to whipsaw the prosecutors, both in the arguments in front of this jury and potentially on appeal, where we know judges are very circumspect and very cautious about the introduction of this kind of evidence?
I mean, absolutely. I've said kind of from the beginning, I think motive is the weakest part for the prosecution in this case. And they are trying to just, say that it has to do with his financial information. That phone call that day maybe was the impetus of it. But one, I don't know how much, if anything, this judge will let in. If anything, it will probably be a small amount. Okay. But even that, like you said, could get appealed. Here's the other thing. It's also his father, as we know, went to the hospital that day, right? And ended up dying 2 days later. You could argue he killed him out of grief for his father. So I think the defense has a strong case that just because something bad happened to happen that day, the prosecution hasn't shown enough of a connection. It's not as if he gets money from the death of the wife, and which I think then the prosecution would have a much stronger reason for admitting this evidence. But are you going to say every single bad thing that maybe happened at that day caused him to kill him? I mean, at that point, I just don't see the connection. Although, yes, his life is falling apart, but you could say that about, hey, his father was also dying. Are they going to, anyway, to me, this is a stretch. Yeah. And if the judge lets anything in, I think it's going to be a small amount.
I think, DINA, that I've had cases like this where the defense is objecting to it because they want to create a record for purposes of appeal, but are actually hoping the judge admits the evidence because they're going to focus on that instead of the other evidence to say, you'll have to believe. Then they put on that this is the reason that he went and killed the apple of his eye and a great relationship with his wife, because they can't come up with any other explanation. NEAMA, let me go to you. You brought this up. Hey, listen, it could be a weak case, so maybe they're pushing the envelope a little bit. So I assume by that statement, the phone evidence may not be as powerful powerful as you think it should be in order to push them to that proof beyond a reasonable doubt. Am I assuming too much in your commentary?
No, that's it. I mean, they really only have two pieces of evidence here, Bob. They have the Snapchat video, and yet Paul's friend testify that essentially Alex lied when he said he was napping, and he was actually in the kennels where the murders happened. So that's one good piece of evidence. The other is the gunpowder residue. I mean, obviously, we haven't seen that yet, but I expect it to come from, Alex's car, his seatbelt, and the raincoat. But really, other than that, what do you have here? You have really no forensics. You don't really have any blood. You have no motive. The other cell site evidence, at least, isn't good for the prosecution. You have two different murder weapons, which at least leads to the defense say that there's two different people. Very difficult circumstantial case. But, if you're jurors, most people, look, I'm a lawyer. We're all lawyers. I'm married to a lawyer. But jurors generally don't like lawyers, especially civil plaintiffs lawyers, personal injury lawyers that steal from their clients. They won't like Alex Murdaugh if and when they hear all that evidence of financial crimes. He's been disbarred. He's lost his license.
But NEAMA, that's exactly the point, that they don't want that kind of evidence to be introduced as character assassination, and the judge has to balance the fact that that's why prosecutors want to admit it, because we all know if you can bloody the guy up over here, maybe they'll make that jump and say, well, he must have done that over there. And it's exactly why the rule says you shouldn't do it, except for very limited circumstances. NEAMA, let me follow up with you on that point of view down the road. Do you believe that the defendant is likely to take the stand in order to explain the phone evidence? And the reason I ask this is my mentors taught me when I was younger, hey, people lie about where they are, and especially in the context of a husband and a wife, because they know they're going to be the prime suspects. And the fact that you lie doesn't necessarily about where he was doesn't necessarily mean he's guilty of the murder. Of course, prosecutors will say that's consciousness of guilt. Where do you fall on it?
I don't think Alex is going to take the stand because the defense is in the lead. They can win this case or hang the jury without him taking the stand. And like you said, the 404B evidence may not come in during the prosecution's case in chief, but if the defendant gets up there and starts telling all sorts of stories, that really opens the door to a wide array of impeachment evidence. So given the presentation by the state so far, and what I believe is that the defense is in the lead, I don't think Alex is going to be taking the stand.
Wow, this is a really nuanced evidential case. A lot of tactical decisions that are going on here.